My Lord, the quorum on the part of the applicant is as it was in the morning.
Thank you. And I don't see Mr. Sudi.
He's coming, my lord.
Okay. Not by a member of the public who may be susceptible to wither under the influence of his MP during investigations, but by the police officer who was allegedly assaulted. 3. Unlawful possession of firearms and ammunition is proved as the learned magistrate ruling correctly held through forensic, documentary, and expert evidence. 4. Resisting arrest is also provable through the factual evidence of police officers who were present at the time of the attempted arrest. And 5. It is unclear what the offense of committing offensive conduct would entail in the circumstances here, but such generality and nebulousness of the allegations cannot be a ground for limiting constitutional rights of an accused person. 2. The state made no efforts whatsoever to demonstrate which witnesses would be interfered with and how such interference would happen at the investigation stage given the offenses contemplated. It is not enough to proclaim that an arrested person wields influence in his line of business, profession, trade, or occupation. In order to restrict the person's right to be released on pre-charge bail, the state must credibly and specifically demonstrate the likelihood of such interference. Second, the argument that the interests of public order, peace, and security necessitate the pre-charge detention of the applicant because his speech has led to quote-unquote demonstrations against him does not meet, in my view, the high threshold of compelling test required by our Constitution. The reason given appears illogical when set against the granted remedy to hold the applicant without charging him for 7 days, then releasing him. There is no indication how holding the applicant for precisely 7 more days will dissipate the public order, peace, and security risk his alleged utterance caused. I have noted that there is no allegation that the applicant has threatened to make like utterances if they are indeed capable of inciting the public. In any event, the applicant has demonstrated a willingness to abide by the condition not to make any comment akin to the ones the state finds insalubrious and capable of inciting the public. What then is the logic of his continued detention? In short, the radical remedy prayed for and granted to the state, which is to hold the applicant without charge for 7 more days, is not rationally related to the alleged risk. There is a second reason to worry about the contextual and simplistic pitting of public order, peace, and security on the one hand, against the personal liberty, interest, and autonomy of the applicant on the other. It is that the logic espoused by this simplistic pitting is a dangerous anti-liberty effort which was rejected by the Constitution of Kenya 2010. I clearly expressed this reasoning in Joseph Young and 17 others versus Republic, and it is sufficient to reproduce here at length the relevant paragraphs. And I quote from that case: the defense would be correct to argue, this was a similar case that was in Kiambu, and this is what I said in that case. The defense would be correct to argue that such a blunt response to the breakdown in law and order would be tantamount to sacrificing the rights of the accused person in order to secure peace and security for the rest of society. Needless to say, our Constitution no longer countenances such an approach. Such was the approach to law and order that justified the authoring into our law books the infamous Public Order and Security Act. The logic that it is necessary to simply detain some quote-unquote dangerous citizen in order to maintain law and order for the rest of the society. That logic has been substituted in our Constitution with the opposite logic, that every accused person is presumed innocent and is entitled to bail and not to remain in remand unless compelling reasons are shown. The authority of the court to deny bail, where compelling reasons are shown, can now not be invoked as a reason for the security apparatuses and the state to refuse to undertake their foremost duty to protect all citizens and maintain law and order in society. Where the alleged sources of threat are known and the potential victims of the illicit activities are known, it would be to reduce the state's monopoly of violence and duty to protect its citizens to a sacrilegious impotence, to conclude that only the remanding of accused persons or suspects who are not themselves alleged sources of threats to protect the potential victims and public order. Having reached here in my analysis, the result appears eminently tautological. There are no compelling reasons for the continued pre-charge detention of the applicant. All the concerns raised by the state can be accommodated without the very radical measures sought and granted to the state to hold the applicant pre-charge for 11 days in the circumstances of this case. I must return to the words I stated in the Joseph Demo case that I cited before. And they are, I'm obliged to observe that the pathway to peace and justice chosen by our Constitution is one that assumes that aggrandizing personal autonomy and liberties, especially in the context of a criminal trial, is one that ensures our optimum aggregate collective peace, security, and justice more than the alternative path that limits individual liberties in order to safeguard these important values and outcomes. Ours is a constitution that wisely assumes that peace, security, and justice can be achieved in the context of the rule of law. For this to happen, each of the actors in the governance, law, order, and security sector must play their rightful role in ensuring sustainable peace, prosperity, and security. The disposition of the application then is as follows. A. The applicant, Sudi Oscar Kipchumba, shall be admitted to bail in the sum of Kenya shillings 500,000 with respect to all the charges the state contemplates to bring against him as covered by the state's application before the lower court. Alternatively, the applicant shall be released on his own personal recognizance of Kenya shillings 1 million and one surety of similar sum. These bail bond terms shall remain in effect and shall only expire upon the formal charging of the applicant with a disclosed offense or offenses. Upon such eventuality, the trial court shall be at liberty to set its own bail bond terms. B. The applicant shall not, and I hope Mr. Sudi is listening here carefully. Mr. Sudi, are you listening here carefully?
I'm listening very
Okay. So, the applicant shall not, before a charging decision is made in this case, and thereafter, until the order is varied by the trial court, make any public utterances or comments akin to those he is alleged to have made, which the state alleges are capable of inflaming public passions and hostilities among communities. C. The applicant shall desist from addressing any public rally before investigations into this case are complete and a charging decision made. Okay? So the third one, I've only limited it to until a charging decision is made. After that, you can address public rallies. Okay? D. The applicant shall report to any police station as summoned by the investigating officer for purposes of completing investigations. E. The state shall be at liberty to charge the applicant with any disclosed offenses once investigations are complete and charging decisions made. Meanwhile, F, the applicant, this is for you, Mr. Karuri,